Afternoon, everybody. Welcome to the 5th MyHR Facebook Live. It's great to have you. We've got a building audience and we've got a bit to cover today, so I'll do my best to get through it and get through it quickly so you can all get back to your day. But if you have to go, or if you want to come back and revisit any of the topics we cover, we do record it. We have them playing on our YouTube channel, on our Facebook page, on our LinkedIn company page as well. So you can go back through. I'd encourage you to like us, follow us, do all of those things, and then you can stay up to date and go back through things. But thanks for tuning in. Today we've got two sort of headline topics. One is around just an update on performance reviews. We've posted a bunch of blogs, resources and tips around performance reviews, staff retention and engagement in the last month. And the other one, of course, is these looming changes to employment legislation in New Zealand. We have a few people who connect with us from overseas, so I'm going to start with the performance review piece. And in that way, when we get into New Zealand specific legislation, if it's not something that's of relevance to you, you can then tune out and head away. So the performance review topic's really interesting, and the reason we've been talking about it recently is because there's been a lot of articles about the death of the performance review, how they're not cool anymore, people don't like them, they don't want to do them, and there's sort of this implication that they've died a natural death. What I've been saying, and I posted this on LinkedIn the other day, is I don't think they've died a natural death at all. I think performance reviews have been murdered by corporate bureaucracy. And I think many of us will know, and many of you will know, that the traditional, corporate performance review is a checkbox bureaucratic exercise, and it can be quite soul destroying, and it doesn't really achieve anything that it's set out to achieve in terms of mutually beneficial outcomes, engagement of employees, proper and accurate measure of performance, and ability to base career progression and reward and feedback, and all of these things. They become these sort of onerous exercises in ratings that are somewhat arbitrary. And I'm sure you're all familiar with these sorts of things. So I think unequivocally that good performance reviews work, and so that's really why I wanted to cover this topic. A good performance review is a very, very powerful tool in an organisation. Fundamentally, performance reviews are conversations. So the associated bureaucracy, whether that's paper or technology, should really be secondary to the conversation. It should just simply support a good conversation, track what you are measuring, help you administer the process to allow you to sit down with your people and have a good chat about how it's going and how it could be better, or congratulate them for jobs well done. So there are a few headline principles I'd just like to cover very quickly today around the performance reviews that we recommend and that I recommend. And that might give you some tips to take this forward. We can do a lot more detailed session on this later if there's some interest in that. But I guess as a headline point, there are a few things I'd like to cover. First one, as I've said, performance reviews are conversations. So don't let the bureaucracy get in the way of that conversation. The second point is use technology. And absolutely, I know I'm somewhat biased. I run an HR tech company, but whether you use us or anyone, I don't care really. It's get away from paper. It's a completely ludicrous way to conduct a review these days. Filling out pen and paper checklists, you complete a review for your employee, they attend with their review completed, you scribble out a third one on a piece of paper, and you've suddenly got 3 pieces of paper, and someone has to administer the pulling together of all of that, at which point it's all about the paperwork and not really about the conversation. So get it online. There are so many great tools out there, and they allow you to be flexible, send reminders, check in notes. They allow you to keep things up to date, to make changes if you need to throughout the year. And at the end, when that conversation comes to the fore and you need to have your assessment process or whatever you do, it is so easy to do. And you're not caught up, with just administering massive amounts of paperwork. I think we all know what it's like in larger companies anyway, where you get that email from HR around the 1st of May saying, please complete all of this by the end of, 1st of March, sorry, please complete all of this by the end of March. And there's 16 attachments and they're each 30 pages long, and you've got to work through competency matrices and all of these sorts of things. A completely soul-destroying exercise. So use technology to help administer that. The second part is how you structure your review. And so what we say is that there are 3 parts to a good performance review. There are the goals or KPIs or objectives, whatever you want to call those things. They are what you need to do in your job to be successful. They're binary measures, right? They are hard measures about achieve a certain result, and it can be measured very, very objectively. Of these, you should have 3 to 5 only. 5 is an absolute maximum. I personally prefer 3. And these are the 3 things over and above your job, in your job, that you need to do to demonstrate success. Turning up on time is not a KPI. Being nice to customers and clients is not a KPI. These are the fundamentals of your job and why you receive a salary. So obviously in, say, positions like sales, these are quite easy. It might be grow sales by 20% this year compared to last year, or by $1,000 per week, or 20k per month, or whatever your metrics are. And you try to balance lead measures and lag measures. So that sales result is a lag measure. It's the result of your actions. And then some lead measures that will ultimately feed that. So what are you doing to grow a sales pipeline? Make X number of calls per week, per month, with an expectation that that results in the expected sales growth. It's not always about sales positions. KPIs or goals work well in positions that have budget accountability, project accountability, have some tasks that they need to complete that are major and will have a significant impact on the business. The second part of a good performance review are your skills and competencies. So what are the skills and competencies you need to help you achieve those objectives and to grow your career within the organisation? These are the softer measures, the somewhat more subjective things. They might relate to collaboration, team working. Some may be technical skills in terms of developing proficiency in certain softwares or coding languages or whatever it may be. But this is where you can have a really rich conversation about how somebody behaves. This is how they do their job. And you can display some of your company values in this space. Because they are linked to those harder and binary measures around the objective, it's a lot easier to have that conversation because that area can get quite emotional. So that's the sort of second part. The third part is the personal development plan. What are the development activities that the organisation will support and the person will undertake to help them develop and improve, to be better at whatever it is they do and to grow their career through the organisation? And this goes whether you are a small company or a big company, believe me. Even if you're an employer of 3 people, you can get quality out of a good and decent personal development plan. There may not be layers and layers of career development you can offer through ranks of management, but if you're an organisation of 3 people, losing one person is a third of your workforce. So being aware of what their career aspirations are and what you might be able to do to support that is very valuable. So there is relevance at the small end and the large end of businesses here. So don't discount these if you're a small company. And so with a performance review structured like that, really if you think about it in terms of pages, which I don't like to do, I prefer the tech, but if you think about it in terms of a written page, it should fit on one page. That should be plenty to cover everything you need to get a good quality conversation from your people. Set regular check-ins, catch up with them on a regular basis throughout the performance review period. Don't be constrained by traditional periods. Most people will set a 1-year performance review that aligns to the financial year, and for many, many jobs that makes total sense. That's the budget year, that's the performance year, that's what the board or the shareholders measure the company on. But in some instances, jobs are project jobs. And I think it's crazy if you've got a project and a project team that are, say, working on something that starts in June and ends in September the following year, and they have a performance review process that's fixed by some corporate rule to a financial year. Meanwhile, they're having their project review meetings and milestone meetings at a different time that aligns to the June to September project. Make them the same thing. That is their performance review. Assess them within the project. Key milestones, key achievements. Are they on time? Are they in budget? What are the issues? What might occur? What are the mitigating actions we have in place? All of those sorts of things. Align it to like real events. It makes so much more sense. And then you don't double down on conversations that essentially become the same. Back to check-ins, like I say, they can be weekly, they're fortnightly, monthly, quarterly. There's no sort of set rule around when you should check in, other than it should be a meaningful cycle. So in some roles they move fast, so the weekly whip or the weekly work in progress is really, really important. You want to catch up on a Monday, you want to talk about what happened last week, you want to get set for the week ahead. But in some jobs that move a bit slower, a weekly catch-up is a bit irrelevant. And I often see enthusiastic managers go, right, we're going to do this, we're going to get that weekly catch up, I'm going to be close to everything, and there's a burst of enthusiasm at the start of the year, and when you get busy, the weekly catch up is the first thing that gets dropped, because you'll often sit down and not have much to say. How's it going this week? Well, probably similar to last week, that kind of thing. So if it makes more sense, catch up quarterly. Then the check-ins are way more meaningful. Equally, if you have a quarterly check-in and it's a fast-paced role, trying to review something that happened 12 weeks ago becomes very, very difficult, and really at that point the horse is bolted. So check-ins are critical. They keep the thing live. It's not something you do at the start of the year because HR said you had to, and then you pick it up at the end of the year and remind yourself what the KPIs were. I guess I'll say one more thing around those KPIs. I said 3 to 5. I'm a real fan of making sure that they are completely and entirely relevant and within the control of the employee. When you have these KPIs, overall safety performance of the organisation needs to be below a certain measure, whether you're measuring lost time injuries or whatever it may be. It's a great statement that you want to be a safe employer, but an individual employee has no control over the entire organisation. Give them a safety goal that they can measure, or an overall profit goal. If they don't control the overall profit of the organisation, they shouldn't have that as a KPI. That sits with the CEO, and only the CEO. Profit-related goals and KPIs relate to the division, department, store, location, region, whatever that the person can actually control. So keep them relevant too, otherwise you just disengage people. So there it is, folks, really high speed, high level kind of touch on the performance review. I just wanted to put that out there on the back of some of these articles around how they're not so cool anymore. If you do them well, they are a very powerful thing. If there's interest, we can certainly pick this up in more detail at a later time. And if you're outside of New Zealand and not too interested in our changes in legislation coming, now's the time you can tune out. But thanks for coming. So, impending law change. So we've had a lot of law change, as you all know, over the last couple of years in employment, and the change in government has heralded a whole bunch more. So these changes aren't here yet. So let's just be clear on where we are at, because the first point is don't panic. I'm hearing a bit of panic about trial periods and what are we going to do. The legislation updates still have to progress through select committee. Now, having said that, I think there is a very high chance that they will pass because the government has the support of all of their coalition partners. And that was particularly evident in the changes they made to the trial period legislation in order to get the support of New Zealand First. So the changes aren't here yet. The way these changes are proposed to be implemented is that once the select committee hearing is complete, it passes through a number of other stages, and there is the final step, which is royal assent, and then it passes into law. The government website is currently saying that 4 months after royal assent, the legislation will be implemented. So I don't have a fixed date on that, but I'm assuming if it goes quickly, this could be October this year that we see the changes. If it takes a bit longer and select committee process is drawn out, it may be April next year. So that's the sort of time frame that we are preparing for later this year or early next year, but we'll keep you posted as things become clearer. So what are these changes? I'm going to focus on 3, and that was in the email that went out to everybody. These are the 3 that I think are most significant to smaller companies and companies that don't typically have union relationships. So the first is changes to the 90-day trial period. So the plan now is simply that if you employ 19 or less people, you can still use trial periods in the same way that you always have. If you employ 20 or more, you cannot. And that's it. Quite simple. So I think about this in terms of 3 groups, actually. I think about those that are probably 17 and under, so who are smaller businesses and likely to stay small below that threshold. I think about those who are 20 and over, so those who clearly do not qualify for a trial period. But there's a third group, and those are the ones on the fringe, companies that employ maybe 18 or 19 people that have the risk of tipping over with a new hire. So I'll deal with, I guess, the easy 2 first. If you're a small employer, 19 and under, and intend to stay that way, it's pretty straightforward. Continue to use trial periods. There are no change. There is no change, sorry. The caveat to that, of course, is do them right, because as we've talked about in the past, trial periods are often mucked up, and it's all around the process. Some of those fundamental rules that the Employment Relations Authority and Employment Court have proven to us that they are completely unwavering on. So the employment agreement must contain a trial period clause. The wording of the clause must align to the legislation. The agreement must be signed before the employee's first day of work, not on their first day, before their first day, and certainly not after their first day. They can't have worked for you before. They must have had a reasonable opportunity to review the employment agreement, seek advice, and ask questions before signing that agreement. So these are some of the key things you must remember. Otherwise, the trial period will be rendered invalid and the employee will be able to take a grievance for unfair dismissal. And so in all of the case law that I'm aware of, where an employee's taken a grievance against the trial period, it's been where they've been able to prove that there was no valid trial period in place. So small employers, you can still use them, just use them right. Larger employers, 20 and above, they're going, that's the end of trial periods for you. And so what does that mean? I'm advocating a return to the probationary period. And you back the probationary period up with two really, really important things: solid recruitment process and a good quality induction and onboarding program. And if you do this, you stand a much better chance of selecting the right people for the job before they come to you. So that should reduce some of the risk that you're going to hire a bad egg. And so it's just about introducing a bit more structure, a bit more rigour to that recruitment process. And we do have some resources around this, and this recruitment is something we can talk about more. But I think the idea that you can just meet someone in a car park, shake their hand and say, all right, mate, you look okay, come on, let's get started. And yes, this happens and happens more often than I would have thought, but that really is not going to help you out and not going to work too well anymore. Proper structured recruitment with decent assessment around them, targeting the job and the type of candidate you want. So number one. Once the person is on board, a decent employment agreement with a good quality probationary period clause that talks about the standards and expectations, that talks about and makes it clear that the employee needs to meet those standards, and that if they don't, their employment may be terminated during the probationary period. So what this does effectively is it places them almost, and I know this sounds quite negative, but it places them almost on a performance plan from the outset for that first, say, 3 months or 6 months, however long the probationary period is. And that means you can assess performance and potentially make a decision to terminate employment without the formal warning, final warning, and dismissal steps. You can go straight to that discussion about an exit if you have a good probationary period clause. And to the third point, you follow a good quality induction and onboarding program. So induct your people well. Really, and I really mean this is fundamental. And when I worked for larger companies, one of the things I would always talk about was any staff turnover in the first 3 months of employment is a point for reflection for the company. We've done something wrong either at recruitment or in our onboarding. We haven't met the expectations of an employee in some way, or we haven't hired the right person for some reason. So reflect, figure out what you did wrong, and improve. So onboarding and induction covers a range of things, from functional, what you need to do in your job, to the workplace and the culture of the company, where you get coffee, how the lunchroom works, what you do when you need to take a break, where the toilets are, all of that kind of thing. And then, of course, some of the rules-based stuff, so company policies and expectations around that kind of thing. Structure it. Induction starts before the first day of work as you're getting everything ready for the employee, and induction and onboarding carries on for at least 3 months, in my view. Set regular catch-ups and regular check-ins, and assign a mentor or a buddy. If you don't like the word buddy, if you think it's a bit cheesy, then use the term mentor. It doesn't matter, but somebody who is a connection point for that new person outside the direct line manager, because they can be great at picking up any concerns or issues that may have. It's an opportunity for the new employee to have somebody to talk to who is not their boss. And if you do that, I think you'll be able to run a reasonably good quality probationary period exit if the employee doesn't work out. Now, you're not protected against the personal grievance, but it will be harder to take and win a personal grievance in that situation. The third group, those on the fringe, I think it's going to be quite a weird space to be, and it's an unfortunate side effect of the law. So If you employ 19 people and person number 19 resigns, it gives you 4 weeks notice, or maybe they give you 6 weeks notice, they're going off on an OE, and you're delighted to have a bit of extended notice because it gives you some time with them in the job. Then you get the great outcome of being able to hire a new candidate, someone who's perfect for the job within a couple of weeks. They're available immediately and you can bring them on and they can get handover from the person who's leaving. You know, this is a great outcome, and it's one that we often want that we don't get. You know, handovers can be quite rare. So what happens in this new legislation, you hire the new person ready for the handover, but they become employee number 20. And as the law reads, at the moment, they will not be able to have a trial period, even though at the end of the induction process, number 19 is going to leave and you go back to having 19 people. The way the law amendment reads is it says that at the time the employment agreement is signed, it's how many employees you have. And so I think for this group it will be quite unusual. I think we might see a rise in, say, the use of casuals, so they can, you can pull back on the books a bit and keep that employee number low. Maybe an increase in the use of contractors, temp agencies, or even outsourcing services. So I think that may be one of the unintended negative consequences of this law, and that may be a rise of, say, contracting, temping, and outsourced services, which reduces the number of permanent positions available in an organisation. I think that's a funny group, so be aware of that. So that's the 90-day trial period. Rest and meal breaks, this one's a classic. I mean, it's a real kind of political football, you know, they always change. For years now, we've just been saying in our employment agreements, rest and meal breaks will apply in accordance with the legislation, because it's the thing that seems to change most often. And somewhat cynically, I'm going to say that I think it's just because the governments can make changes to something quick and easy and be seen to be doing something. We've gone from having quite onerous and prescribed rest and meal breaks, defined in law after 2 hours, before 4, between 4 and 6, between 6 and 8, 8 and 10, and on and on and on, to having a really open way that we had last time, that breaks can apply in a consultation with the employee and employer, and that the employer doesn't have to provide breaks if they provide reasonable compensation. So allowing a real open sort of management of breaks. And now we're going back to the prescribed version. What can I say? It is what it is. You need to be very careful that you apply those breaks, that you are aware of that wording. The wording is fairly easily defined, so getting it into employment agreements isn't a problem if you want to do that. My recommendation is you just say in your agreements, look, breaks will apply in accordance with the law. And if you want a breaks policy, then that can change as the law changes, because probably if there's another government change in 3 years, we'll have a new set of breaks legislation. So that's what that is. The only difference this time round is this new breaks law lands at a time of the new health and safety law. And so be very careful of not providing the breaks that you're required in law, because you may also fall foul of your requirements and obligations under the Health and Safety at Work Act. The last one, before we wrap up or deal with any questions that have come in, is the return to reinstatement as the primary remedy for a personal grievance. Now, this is a little sneaker inclusion. No one's really talking about it. And I think it's a big deal, actually, because any of you that remember when this was around, it's a really, how do I say it? It's a weird piece of law, like what happens is you have a point where the employment relationship has just kind of dissolved and things have gone really badly and an employee has left, or they have been dismissed. Now, sometimes they have been dismissed for very legitimate reasons. They may have been found to have been bullying or harassing an employee or a bunch of employees. They may have been found to be stealing. And the substantive justification for the dismissal might be sound. That means we have proven that they have been harassing employees. But the process for dismissal may not have been 100%, and that opens the door for a grievance. The employee, in raising their grievance, states that they want to be reinstated, and that's all they need to do under this legislation. And while there is allowance for the Employment Relations Authority to determine whether or not reinstatement is fair or practicable or reasonable, there's not really any clear guidance around that. And so potentially this harasser who has been dismissed from the business for good reason can sit there and claim reinstatement. And obviously they cannot come back to the organisation. It will harm and affect the safety of others in the workplace. So what happens is it's used as a tool to ratchet up the settlement payment. And they sit there going, yeah, I'm happy to be reinstated. No, I don't need compensation. I'd like my job back, please. At which point the cost of maybe signing a deed or a record of settlement and agreeing on an outcome suddenly goes up because the employer does not want and cannot have that person back in the workplace. So I think it's a somewhat cynical piece of law. All it really does is increase the amount that people can ask for during settlement discussions. I don't think it achieves anything positive in terms of returning people to work because by the time that dismissal occurs, the relationship is usually pretty broken. So watch out for that one. I think when you overlay that to businesses of 20 and above, with the removal of the trial period, that may be an area where it's affected. You know, you hire someone, they turn out to be completely inadequate for the role. You put them through training, onboarding, induction, they still don't come right. You undertake a fair and reasonable probationary period termination, but they take a grievance and seek their job back. That could cause some difficulties, I think. So those are the three headlines. Obviously there's a bit more in there around union rights and protection of vulnerable workers, but I've focused today just on those ones that affect more of the client profile that we look after. It's been a good session. I'm getting a wave from behind the camera. I've got a couple of questions apparently, so we'll deal with those and go from there. So Justine, can an employer force an employee to come to a team building day if the employee is only paid on a fee percentage basis? They don't get paid if they don't earn fees. Yeah, Justine, it's a really interesting one, right? So you're compelling a person to work, but potentially to work without pay. So I think you need to think about what, I guess maybe what the purpose of the team building is, what the employment agreement says. So if you have an employment agreement that states quite clearly that a couple of times a year the employee may be required to attend training or team building days for which they won't earn fees and therefore won't be paid, but with the intention that this improves their ability to do their job and achieve better fee payments or commission payments, then that might be seen to be reasonable. But I think if this wasn't heralded or flagged in the employment agreement, it wasn't agreed to up front by the employee, and you were requiring them to come into work for 8 hours and receive no remuneration for it, I think you're potentially at risk then. You know, the fundamental of the Wage Protection Act is people get paid for work that they do. So, yeah, I having not read the employment agreement or your company policies, I do think there is some risk to compelling that employee to attend. I'd like to think if there was a good relationship, good company culture, you had good levels of engagement and good relationships, that it's the sort of thing that an employer would go, yeah, I'm into this, I'll come along. Team building improves my connections to my colleagues, it helps me do a better job, it therefore means when I'm back at work I can do better and therefore earn more. So there's potentially a compelling reason why someone would attend. But without a clause in your employment agreement, I think there is some risk of compelling that person to turn up, I'm afraid. Hope that helps. Thanks for the question. And there's another one too. This is Donna. What do you do if you don't have a contract and when you ask for one they respond with, you don't want to go down that track? Wow, okay. Hey Donna. So contract, we always refer to them as contracts. The correct term is employment agreement, but it's the same thing, right? It is a requirement under the Employment Relations Act of 2000 to have a signed written employment agreement for every employee, no matter when they were employed. And so that was put into law on the 2nd of October 2000. It was Helen Clark's government that did that. So it's been nearly 18 years. In about, I'm going to say 2011, but I'll have to check. But in about 2011, a fine was added to that. And in 2013, I think the first fine was levied. So your employer risks a $20,000 fine if they do not have and cannot produce a signed written employment agreement for every employee, no matter when they started. So our law is really clear on this. You cannot work without a signed written employment agreement. There are no verbal agreements or handshakes anymore. The old letter of offers that used to exist under the Employment Contracts Act, where you sort of got a one-page letter that said, you do this job, we'll pay you $10 an hour and good luck. It's all gone. You need an employment agreement. There are a list of mandatory clauses that agreement must have. So they don't really have a choice in this matter, I'm afraid. Thanks for the question.
That's it.
All right, that's it. Hey, thanks everyone for tuning in. Another cool session. We'd like to keep them brief. The next one will be next month. We'll run some advertising around what it is. Like I say, it's recorded, so you can check it if you want to look at anything else. Or get in touch with us. Follow us on LinkedIn, like us on Facebook, and I look forward to connecting with you again. Thank you very much.
There was somebody who was saying that they were looking forward to seeing you in Australia. So if you want to tell me about that.
Oh, right. Yeah, well, we're on our way to Aussie, actually. So Esteban off camera is just telling me that we've had a message saying looking forward to us arriving in Aussie. And yes, we have plans to launch in Australia. So that's all underway at the moment. I'm not going to put dates to it just until I need a little bit more of the project defined. But it will be pretty soon. And I'm also looking forward to it. It'd be good to get back there and see some of my Aussie mates again as well. Thank you very much.